Are the ACTA agreements themselves legally valid? No. The ACTAs rely upon an erroneous definition of the IRS as a lawful bureau of the Treasury, a claim demonstrably false per 31 U.S. C. Section 301 F. 2. By asserting federal legitimacy without statutory basis, these agreements misrepresent the IRS's legal character. Further, ACTAs appear to violate state-level procurement statutes mandating open bidding for contractual services. No public record indicates that the IRS competed for these agreements. The result is an unlawful monopoly in tax administration services, supported by misrepresentations and administrative coercion rather than the rule of law. 4. Can the IRS legally use Department of the Treasury on its outgoing mail? No. The use of Department of the Treasury in the IRS return address is misleading and legally problematic. This designation falsely implies that the IRS is a bureau lawfully established within the U.S. Department of the Treasury, when no such organic statute exists. Under federal law, particularly the mail fraud statutes, 18 U.S. C. Section 1341, and provisions found in 31 U.S. C. Section 333, knowingly using U.S. mail to advance a fraudulent scheme or convey false governmental authority constitutes a criminal offense. Therefore, each IRS letter bearing the Department of the Treasury return address constitutes a potential count of mail fraud. Does the U.S. Department of Justice have power of attorney to represent the IRS in federal court? No. The IRS is not a federal agency as defined in the Administrative Procedure Act, APA, or Freedom of Information Act, FOIA. See 5 U.S. C. Section 551(1)(c). Because IRS operations are territorially bound to Puerto Rico, a federal possession excluded from the APA and FOIA definitions, DOJ lacks statutory power of attorney to represent the IRS in judicial proceedings. Authority to represent the IRS resides with its chief counsel, appointed pursuant to 31 U.S. C. Section 301 F. 2, and not with the U.S. Attorney General or DOJ. The statutory chain of authority flows from Congress to the President, and then to the IRS chief counsel, not to DOJ or its litigating divisions.